Good afternoon, everybody. It looks like we are now live for our webinar today on HOA foreclosures. Are they still a good idea? I see about 75 people have logged in so far, and I believe there's about 160, maybe 170 people signed up. So we've got a couple more coming in, I hope. But I wanted to just introduce myself. My name's Kate Leeson. I am an attorney here, obviously, in our litigation department. I've primarily handled foreclosures for the firm since about early 2018. So for quite some time, I've seen a lot of changes come through, and I'm going to talk today about a lot of those changes, and feel free to ask me some questions at the end of this webinar. But let me give you our housekeeping details here. On your screen, you should primarily be seeing the PowerPoint presentation. You should also see a small box on the left-hand side of the screen with a picture of me in there. On the right side of the screen, you'll see a private chat icon. Please use that icon to type in your questions throughout the presentation. I'll address those questions at the end of the presentation if there's time permitting, and if not, I'll still get to your questions. I just won't be able to do it on live through the webinar. If you have any audio or video issues during the presentation, please click the no audio or video button below the PowerPoint on your screen and follow those instructions. One CMCA credit will automatically be generated for you and emailed to you within 48 hours after the webinar, assuming you attend the entire program. Your credits are not transferable. As a reminder, this presentation will be recorded and added to the Altitude YouTube channel within a couple of days. And lastly, there will be a survey that will pop up at the end of the webinar. We truly appreciate any feedback that you can provide. Your thoughts and opinions assist us with improving our future presentations, so please don't hold back. Be honest about your opinions. Unless you don't like my seminar, and then don't be that honest. Okay? So without further ado, I'm going to go ahead and get started. I'll try to talk slowly because I tend to talk very fast, and I'll get through all the information, and like I said, I'll try to make time for questions at the end. So today's topic, HOA foreclosures, are they still a good idea? Foreclosures have been the target of legislation since 2022 due to the situation in Green Valley Ranch. And for those of you that may be newer to the industry, you may not recall what happened back in Green Valley Ranch. There were a lot of foreclosures. There was a lot of uproar throughout the community, people alleging that they never received notices and all of a sudden they no longer own their homes. Based on a lot of those allegations, our legislatures decided that they would do something about the foreclosures that happened. If you'd like some more information about what truly happened in Green Valley Ranch, there were a lot of articles that were written about it. A lot of those articles I found had very slanted opinions in them, but that's not what this presentation is about, so I don't want to belabor the point there. But just know that that's really been the legislature's goal since about 2022 to reform foreclosures just based on what was happening out in Green Valley Ranch. But our legislature's alleged aim is to keep people in their homes, always a good goal. And more recently, some of the changes have been passed to help homeowners preserve equity in their homes. So to start, why do HOAs foreclose to begin with? At times there's a corporate owner or a trust ownership, and getting a judgment against a corporation or a trust, while not unduly difficult, can be very difficult to actually collect it. At times there's a deceased owner and no one's taking responsibility, so foreclosure is usually your way to collect that debt. Owners will have very large balances. And in the collections industry, if you work in that industry at all, you realize once the balance gets to a certain point, it's almost impossible for a homeowner to come up with a reasonable payment plan or just to pay a large balance overall. And so foreclosure tends to motivate homeowners to pay. If a homeowner is habitually delinquent, oftentimes a foreclosure gets them back on track, so to speak. And sometimes it just forces an owner to realize that maybe they can't afford the home, or maybe this is just a financial responsibility that they don't want. And so they'll sell their home to take care of their obligations. Oftentimes there's unsuccessful collection of a judgment via wage or bank garnishment. So even if you do have a judgment, it just isn't collectible, and the association may want to take that extra step to try to collect it by foreclosing. And should an HOA actually foreclose? There's some debate about that, and I think boards in general don't like to foreclose. It's been my experience that they'll look to other options first, but boards have a fiduciary duty to their owners to collect assessments. We all know that you can't run the community without assessments, and a foreclosure is really your most effective collection tool. And again, boards don't really want to take that step, but sometimes you just don't really have an option for collections, or you've run out of other options. So in 2022, we saw legislature that specifically targeted HOA collection and foreclosure procedures. These changes caused a huge backload in collections, and in many cases resulted in a lot of do-overs in collection notices in order to foreclose. I know a lot of the managers out there are thinking, yep, we sure did. We had to do a lot of do-overs. It's not fun to have to tell a manager or a board that we'd like you to resend all of these collection notices because they no longer comply with the legislation or your collection policy. And there are very specific requirements for foreclosure. And so some of the older notices just simply don't comply or allow you to foreclose. In 2022, we saw House Bill 1137 get passed. And this was sort of where things started to crumble. And there were a lot of effects of 22-1137. Some of those effects were having to include in your delinquency notices that the owner be told that unpaid assessments may lead to foreclosure. Because I think in general, overall, owners just were not aware that an HOA could foreclose. I think everybody's aware your lender can foreclose, but not so much your HOA for past due assessments. And so 22-1137 made it a specific requirement that you tell an owner if part of your balance is unpaid assessments, it could lead to foreclosure. Another huge change for the industry was taking out the 6-month payment plan that was required to be offered and changing that to an 18-month payment plan. And you had to offer that before you could initiate foreclosure. And the payment plan had to specifically allow for minimum payments of $25 per month for 17 months with a balloon payment in month 18. And for those managers who have experienced that 18-month payment plan and getting $25 a month for 17 months, it was very rare that that 18-month balloon payment plan ever materialized. So you ended up foreclosing, you just pushed it out for 18 months. Some other effects of 22-1137, foreclosure could only be initiated for outstanding assessments if the owner missed at least 3 of the installment payments that were due or declined to enter into a payment plan to begin with. And so you might have an 18-month payment plan where the owner misses month 16 payment or misses 2 payments before they ever get to 16. You know, they would spread it out over the 17 months, so you still might be waiting 17 months before you can take any action. Another huge change for the industry was no more foreclosures for just fines, late fees, interest, or legal fees. They had to be past due assessments. And of course, for a foreclosure, you have to have at least 6 months worth of past due assessments before you can foreclose anyway. That never changed. And it's still 6 months worth of assessments must be due before you can foreclose. But if the only balance is fines or late fees or legal fees that were incurred enforcing the declaration, you can't file a foreclosure. Another big deterrent to foreclosure litigation from HB 22-1137 was that it initiated a 5-year statute of limitations for an owner to bring an action for a violation of any foreclosure law. And the owner could be awarded up to $25,000 plus costs and attorney's fees if they were able to prove a violation. 5 years is a very long look-back statute, so it became incredibly important for, I think, all attorneys handling foreclosures and boards and managers to make sure that we complied with every single procedure that was required, because $25,000 is also a very large sum of money, plus their attorney's fees and cost. So was 2024 the beginning of the end? We saw a lot more changes come through 1337. And my slide does say the legislature does not appear to have a firm grasp on the actual foreclosure process. And I say that with no disrespect to our legislature. I just think that people outside of the industry who are looking from the outside in don't really know what the process is. They don't really understand what the motivation of a board might be, or how the attorneys even handle these types of claims. As I said earlier, I haven't run across a board that is really gung-ho for foreclosures, like, yes, let's take their home, let's do this. Nobody wants to. A lot of times they just don't have an option for collection, and since the associations must have those assessments in order to run the association and pay for everything, foreclosure becomes an option. But I think the legislature just looked at it as a way for HOAs to further control and have the ability to take people's homes, and they didn't like that. So that's what I say. That's what I mean when I say they don't really have a firm grasp on the process itself. So 1337 has been ruling our lives since last August of 2024, and added a lot of new prerequisites before you could foreclose. One of those prerequisites, which is not really a huge deal in our industry, because most boards will have their attorneys go ahead and file for a money judgment first before they take any action to foreclose. But 1337 made it a requirement. You have to file your civil action to obtain a money judgment and get that money judgment before you can foreclose, unless the property is owned by an entity, so a corporation, a trust, somebody other than an actual real live person owns the property, or the property is not the owner's primary residence. You might have somebody who has a recreational property and doesn't live there all the time, or it could be a commercial property where nobody lives, so it's not their primary residence, so you would not have to get that money judgment first. Or you've filed your money judgment or attempted to obtain service on the owner, and the owner is successfully avoiding service and has done so for at least 180 days, 6 months. And if you've not been able to serve the owner within that time, then you can forego that prerequisite of getting a money judgment. Those are your exceptions. I'm not mentioning timeshares here. Timeshares is a separate animal, and 1337 doesn't apply to timeshare foreclosures. Another effect of 1337, you must now send a notice to an owner advising them that mediation is available at least 30 days prior to filing a foreclosure action. And you have to send this notice via mail and email. You have to at least attempt that, because we know that a lot of times we don't have emails for owners. In addition to that notice, you have to send a notice to any lien holder of record, so anybody who's recorded their lien in the county where the property is located. You have to send those lien holders a notice of a pending foreclosure, and that notice has to tell them what the balance is due, tell them they can pay it, and you have to send that notice via mail and email. There's not any requirement that a lien holder include an email address on their lien. There's not a requirement that they list a mailing address, but most of the time they do. And so a challenge has really been finding an email address for some lenders. I mean, if it's Bank of America, you can go to their website and find a generic email. But some lenders, it's just not that easy. So that's been sort of an impediment to following that requirement. Fortunately, a lot of lenders' attorneys have been very kind and forthcoming in providing emails for their clients in order to send out this notice. But again, both of these notices have to be sent at least 30 days prior to filing the foreclosure action. Additional effect of 1337 created more prohibitions on persons who are able to purchase a foreclosed unit. So if the unit goes to a foreclosure sale through the sheriff, a board member cannot purchase this unit. Management company employee. as long as they're representing the HOA, cannot purchase this unit. A law firm employee, like myself or my paralegal, or any other attorney or staff member of the firm, as long as we represent the HOA, cannot purchase this unit. An immediate family member of all of the above, the board member, the management company employee, or the law firm employee, cannot purchase this unit. The community association management company cannot purchase this unit, and that includes any affiliated or other owned business entities by that management company. And there's a 5-year look-back period. So if there's a board member who was a board member, not currently a board member, but was a board member 4 or 5 years ago, cannot purchase a unit that has gone to sale through an HOA foreclosure. 241337 also created new categories of alternate lieners. Now, you may not know what an alternate liener is or a liener to begin with, but there are redemption rights that go along with being a liener on a property. So anybody who has a lien on the property has redemption rights. And redemption just means that you have an opportunity to purchase a property that is going to sale if you have a lien on it. And you can do that outside of the bid process by filing a notice of intent to redeem. Usually people who are redeeming are second mortgages, or you have another sub-association that has a lien on the property and they decide they'd like to redeem. You don't really see a whole lot of other lien holders that redeem. Usually the property just goes to sale, the HOA gets paid and you're done, right? But 241337 created all these different new lien holders who had rights of redemption. And those categories now include the owner. Many years ago, and I don't actually have the number of years, but many years ago, the owner was allowed to redeem the property. The law changed. The owner was no longer allowed to redeem following sale. Well, 1337 brought that right back to an owner, and an owner may now redeem following a sale. Not yet had an owner redeem following a sale. Of course, this just went into effect August of last year, and I haven't even had that many foreclosure sales since that time. But typically, from what we see, an owner who's unable to cure the balance before it goes to sale is probably not going to have the funds to redeem. But 1337 gave them that opportunity to redeem. And so tenants also, under certain conditions, can redeem. Okay? And that doesn't really seem to make a whole lot of sense to me, but apparently the legislature felt like anybody who was living in the property at the time would potentially want to purchase that property. So they now have the right to redeem. And there's these other categories, nonprofit entities whose purpose is to develop or preserve affordable housing, a community land trust, a cooperative housing corporation, and the state of Colorado, or a political subdivision of the state of Colorado. They all now have redemption rights as alternate lien holders. Again, I have not yet seen anybody actually do that, but they have the right to do it now. And it also increases the redemption period for these alternate lieners. So any of the recorded lien holders who want to redeem have 8 business days following the date of the sale in order to file their intent to redeem. Alternate lieners have 35 days to file their intent to redeem. So that pushes the sale process out a little bit, but they also have 180 days to make payment, another 6 months. And what the statute doesn't come out and say it, but what it allows for is an owner can then delay the transfer of title to their property by filing an intent to redeem within 35 days after the sale takes place, but deciding on day 180 or day 179 that they're not going to remit payment. So the title to the property hasn't yet transferred yet. So they can kind of hold up the sale that way. And I was going to wait until the end to answer questions, but I see a question here that's pretty timely. What is the HOA's position in relation to the first mortgage? So I will talk about lien priority, but just answering that question, there's 2 different priorities for the HOA. They have first priority over all liens for 6 months worth of assessments, right? So that's your super priority lien, 6 months worth of assessments. The first mortgage holder then comes into play, technically their second priority. And then the third priority is the remainder of the HOA's lien. And then there's everybody else. I will touch on that in more detail. I just wanted to answer that one question. So there are also some Denver local laws that have not really complicated foreclosures. They just add another layer of things that have to be done before you can foreclose. There's an ordinance, sorry, I forgot the word there for a second. There's an ordinance that was enacted in Denver in June of 2022 that became effective August 30th of 2022. So just after 2022, 11/37 became effective. This notice must be provided to an owner 30 days before you file a foreclosure action that advises the owner of what their rights are. And it's on a form that's provided by the city, so we don't have anything to do with creating it or what it says. I mean, we could create one and get it approved by the city, but the city has already done that. So again, one more layer of things that you have to do before you can foreclose if the property is located in Denver County. Just a little bit more information on that. The notice has to contain a listing of legal and housing resources for any owner that's facing foreclosure. And important for managers and boards, you have to maintain a record of that notice, including the date and time the notice was provided. The ordinance doesn't say it has to be sent any way other than first-class mail, so you can just drop that in the mail, note in the file when you did that, keep a copy of it so we know which version was used, and then you've complied with that particular ordinance. So what's coming down the pike here in 2025, right? Legislative session is still in place. And it's kind of a little bit scary here, what's going to happen if some of the laws pass that they're proposing, but just specifically with foreclosure. You know, it's not surprising to most of us in the industry that the legislature continues to make changes for foreclosure provisions as well as their sales of the properties. So there's new legislation that was proposed that's slated to become effective October 1st, rather than August, which the last several changes have been effective in early August. This one's slated to become effective October 1st, 2025, if it passes. And HB 25-1043 is the name of our legislation being proposed right now, the current bill. It is truly scary. If you read through it, there are so many different hoops to jump through that it's amazing what the legislature thinks needs to happen. But 1043, as proposed, if it's passed, will require strict compliance with HOA laws and your governing documents. If you've not strictly complied with every single notice, dotted every I, crossed every T, included every bit of information that is required to be included, you are not in compliance with HOA law. And if you have foreclosed, you're allowed a cure period, meaning that the law will allow you to go back and fix what you didn't do correctly. Okay? So when you send over a file to our office or to whichever attorney's office you use, and that attorney reaches back out to you and says, we would like you to redo these notices, please. Don't be surprised, because you've done something, not necessarily wrong, but just something that didn't strictly comply with a requirement. And a good example would be providing more notice to an owner than what is required. If your collection policy requires that you provide a first notice and a final notice, but you throw in an intermediate one, or maybe you throw in a courtesy notice because, you know, more communication is better, right? That's the intent. I don't see a court getting upset that you provided more notice about it, but it doesn't strictly comply with the requirements. So maybe reach out to your attorney and say, is it a good idea if I do this? Am I required to strictly comply? Technically, I'm not required to send out this notice, so why would I? So just keep these things in mind. You know, if a notice says you will send it via email and mail, certified mail, regular mail, whatever the requirement comes up to be, make sure you do it that way. if there's a checkbox on your notice that says, if you owe assessments and you haven't paid them, that may lead to foreclosure. But if you didn't check that box, then you haven't strictly complied. So make sure that your letters all have all the correct language in them, or we'll end up sending it back to you and ask you to please redo it, and here's our corrections. If 1043 passes, you will be asked to revise your collection policy yet again. Okay? More information is being provided to owners, again, if 1043 passes. Owners have always been able to request a copy of a ledger, and you're required to provide them a name of a person, right, that they can contact. In this case, 1043 not only requires you to provide that ledger if requested, it has to be provided within 7 business days. You have to include that you will provide to the owner that there is free information available regarding collection and foreclosure that's available online from the HOA Information and Resource Center. You're asking yourself, what is this HOA Information and Resource Center? Good question. 1043 proposes to establish an HOA Information and Resource Center so that owners can obtain information. They're also establishing that Information and Resource Center to collect statistics. And associations will be required to register with this resource center and provide certain statistics to them regarding foreclosures. I didn't specifically include it in this presentation, but there'll be information you need to provide about the number of owners who entered into payment plans, the number of delinquent owners, the number of owners who have been foreclosed on, or the number of foreclosures that have been filed, the number of homes that have been sold. So there's data that they're trying to collect under the guise of providing information to owners. So HB 25-1043 also advises that you include more information to an owner. This is just a continuation of the prior slide. You need to let the owner know that the sale of the unit at auction to pay delinquent assessments could result in that owner losing some or all of the equity in the unit. So you have to inform the owner of that. You have to inform the owner that there's availability of instructions on how to access certain free online information related to foreclosure. So it's a lot of information being added to a notice that is probably already a page and a half, if not 2 pages, probably be somewhere around 4 pages by the time it's done. And we know that owners claim, one, that they don't receive these notices, or they don't thoroughly read the notices, and now we're going to ask them to read a 3 to 4 page notice that has all of this information on it. It's unlikely that people will actually read this notice. So as proposed, HB 25-1043 wants the HOA to send written and electronic notice to an owner, advising the owner that they have the right to participate in credit counseling. Not just the mediation notice that's currently required, but that the owner has the right to participate in credit counseling at their expense, and how to find this information. This information will ultimately be included on the Information and Resource Center's website. And the HOA is also required to provide details as to what credit counseling may include. Starting to sound like a really long notice, right? So HB 1043 also proposes to add factors that the court can consider in determining reasonable attorney's fees in foreclosure of a lien, to include whether the HOA incurred additional fees due to a stay in court proceedings to allow the HOA to strictly comply. So what that means in English is if the HOA didn't strictly comply with all of the requirements and they had to go back and fix things under that cure process, if there are additional fees that are incurred by the HOA, they're not allowed to charge those to the owner. And I should say, and the court's allowed to consider whether or not they can charge them. I'm pretty sure the decision will be that they're not allowed to charge them. But that's just conjecture on my part. Hasn't happened yet. Court hasn't considered it yet. So really my attorney answer is it's going to depend. 1043 also proposes that if there's any stay of any proceedings, that the HOA is not permitted to impose late fees, interest, or any other type of delinquency charge during a stay while it comes into strict compliance with the law and governing documents. So again, they're protecting the owner if the HOA fails to strictly comply by saying, okay, great, you can have a cure period, but you can't charge the owner. So if the owner has been incurring late fees and interest because they aren't paying their assessments, but yet the HOA didn't strictly comply with all their processes and procedures, you have to put those charges on hold, cannot charge them during that stay time period while you're coming into compliance. Even though under other documents, you actually could charge those. So 1043 also proposes that HOAs shall, and so shall in the legal world means you absolutely have to do it. It's not a maybe type of thing. So you must periodically request the telephone number, a cell phone number, and an email from an owner for notification purposes. However, what's really interesting is that 1043 does not require an owner provide this information. So homeowner associations are required under certain laws to provide a notification via telephone, cell phone number, text message, email. We've all seen that come into play where you're asking your attorney, well, I don't have an email, or I don't have a phone number, and I have no idea what their cell phone is, so I can't text them anything. What do I do about that? Well, this is their resolution. You can ask them for it. And a lot of communities have already adopted these policies based on 1337's requirement that you send out notices in a certain way. And so 1043 is just saying that now the HOA is going to be required to periodically request this information, but not require that an owner provides it. So 1043 is working to try to correct notice defects. And a defect is being considered those situations where you don't have that telephone number or cell phone number or email in order to send a notice to owners. The correction process is you can now send that notice via regular mail. If you remember from 1337, sorry, I was going to back up even further. I don't want to start confusing people because all these numbers start to run together. But back in 2022, when we had the posting requirement, the certified mail, the regular mail requirement, 1337 in 2024 changed those requirements to certified mail. They took away posting and regular mail and added in 2 of the 3 notifications via either telephone, email, or text. You had to do two of those 3. And so, as I just said, a lot of times we don't have that information for owners, so you're unable to provide the notices in those methods. So 1043 is proposing that HOAs now be allowed to send the notice via regular mail to make up for some of those notice deficiencies by not having the other information, which is a good thing. We still recommend notices be sent via regular mail. Problems with certified mail, as we all know, owners don't pick up certified mail. Certified mail is never good news, right? Who picks it up? So the regular mail is great to send it as well. 1043 is a very long statute. It proposes a lot of information. Another one of those shall requirements, if it passes the way that it's written now, that an HOA is supposed to provide information to all lien holders no later than 5 days after an action is foreclosed via written and electronic notice that a lien holder has the right to cure non-payment, and also of an owner's right to file a motion to stay the sale of the property for 9 months to sell the property. I find this to be a really interesting offer to an owner, or option for an owner, that once a foreclosure action is filed, an owner can file a motion with the court saying, I would like to sell my property and I would like 9 months to do that. Can you please put a hold on this litigation? And the court is required to do that. One thing that's also interesting to me is that the statute specifically states that if there's a designee that the unit owner has designated, so if they've designated someone to act on their behalf, that designee can also file a motion with the court. I personally see that as practicing law without a license, because unless you are an attorney, you're not able to file something in a court on someone else's behalf. And so this statute would allow that to actually happen, and I don't think the courts will allow it to happen. I mean, same thing if you have a power of attorney for someone. It doesn't make you an attorney by having a power of attorney, and it does not allow you to file court documents on behalf of somebody else. So again, interesting. Maybe only to law nerds, but still. In this person's opinion, in my opinion, if 1043 passes as it's written, there'll be a very chilling effect on foreclosures. And I think it will cause HOAs to only foreclose as a very last resort. There's just so many hoops to jump through, so many notices to provide. But if you want to foreclose, or if you have a need to foreclose, this is what you're going to have to do. Now, the legislature has not made any decisions on 1043 as yet. It's passed the House several times. It's back and forth. It's slated right now, at least as of this morning, was going to be heard, I believe, on the Senate floor at 9 o'clock this morning. I didn't see what had happened there. And then there's also scheduled to go back before the House the very last day of the legislative session. So we may not know anything until early May as to what happens with this bill. But that's only if it's passed the way that it's written. Okay? And there could be additional amendments. So just some general foreclosure information for everybody, because I realize foreclosure is kind of a nuanced area. And unless you're doing it on a regular basis, some of the stuff I'm saying may not even make any sense to you, and please feel free to ask questions if it doesn't, because I do this, or at least I did, on pretty much a daily basis for a number of years. But I get a lot of questions about an HOA foreclosure versus a lender foreclosure. Lenders typically foreclose through the public trustee's office through a power of sale in their deed of trust. And lender foreclosures are pursuant to Rule 120 versus Rule 105, which for managers, it doesn't make any difference whatsoever how we do it, just do it. But the lender's foreclosure process begins by recording their notice of election and demand, an NED. And typically that process, from the time the NED is recorded to the sale, it's usually about 4 months. It's a very short process. HOAs don't have a power of sale on their documents, so we have to foreclose through the judicial process. And those lawsuits get filed in the district court where the property is located, pursuant to Rule 105. And it's not on this slide, but one thing that I recently learned from lenders' attorneys is that there's at least one new case out there that says if there is a recorded lien that is a federal lien, such as from HUD or Fannie Mae or Freddie Mac, that the lender may no longer foreclose through the public trustee process. They have to file it judicially. So if you're checking for public trustee foreclosures for properties, you're also going to need to check the court system, the county in which that property is located. So if there's any questions, you have to be an attorney to be able to go into the system to look for filings. So please let your attorneys know if you're looking for something in particular, and we can always go look in the court system to see if a lawsuit's been filed to foreclose by the lender. Okay. Another question that I get a lot is about the super lien and when it's applicable. So it doesn't matter if the foreclosure action is filed by the HOA or the foreclosure action is filed by a lender. The super lien is applicable to both types of foreclosures. You calculate that 6-month period of assessments, and it's a backwards look. So when the NED gets recorded, it's 6 months prior to the recording date. So if you're over 2 different periods of time, such as 2 different years, you would be including assessments that may not be at the same amount. Like if it was $100 in 2024, but it's $200 in 2025, and your NED, the 6 months prior to the date the NED was recorded, hits both years, you need to look at those dates specifically to make sure your calculations are correct. Okay. And it's also calculated 6 months prior to the date that the lawsuit was filed for foreclosure. whether it's happened to be a lender foreclosure or an HOA foreclosure. And another common misconception about super liens is that it's always applicable. If there's no deed of trust, then there is no super lien. Because remember from earlier today, I described a super lien as being, I did say the super lien. It's that lien for which the association has a higher priority than the lender. Okay? That hierarchy being the association's super lien for 6 months, the lender's lien, and then the association's lien for the rest of whatever the debt is owed. And if there is no deed of trust, then there is no super lien. Please feel free to ask me follow-up questions on that. And so we know, I'm sure managers know this as well, there's a lien for assessments under Kiowa. It's under section 316. And there's a statutory lien for assessments. You don't actually have to record a paper lien. It can be a good idea because some title companies forget that HOAs have statutory liens, so they don't always look for those when they're doing a closing. They may completely forget about it, and then the association gets left out of payment if the property is sold. And one interesting thing that has been changed in our liens is that while the association still has a lien for any fees, late charges, attorney's fees, and fines and interest, they're subject to that statutory lien, but they're not subject to a foreclosure action. As I said earlier, the owner may owe fines and may owe attorney's fees, but if that's all they owe, you can't foreclose on that balance. And it's sort of the same situation with liens. Those are included in the lien, but not subject to a foreclosure. I'm going to repeat myself here. Recording of the debt constitutes record notice and perfection of your lien. You don't have to record a hard copy lien. Associations are entitled to their cost and reasonable attorney's fees. But what is a court considering to be reasonable? Is it the $5,000 limit that's now imposed? You may recall from 1337 that attorney's fees are being limited to 50% of the balance owed up to $5,000, whichever is less. Courts are going to be considering a number of factors, and when they award attorney's fees, one of those factors is, was the owner litigious? Did the owner really cause the association to incur additional attorney's fees? And so they may award more attorney's fees based on that alone. They may find that this was a particularly difficult case and award additional attorney's fees. The court may also find that it was a particularly run-of-the-mill case and that the association is not going to be awarded all of their attorney's fees. And we are definitely seeing a trend in not awarding all of attorney's fees. Knock on wood here, I've not yet seen that in foreclosure actions. And so I imagine it's coming in the future, but right now we're good. See it a lot more in collection actions. So the question earlier was priority, and this statute is part of 316A, and it sets out where your priorities are. And it specifically starts out with that a lien under this section, 3833.3-316, which is part of Kiowa for HOA assessment liens. And so the HOA lien under that section is prior to all other liens and encumbrances on a unit, except liens and encumbrances recorded before the declaration. And you just rarely see that there's going to be a lien or encumbrance for a dollar amount that's recorded before the deck. And the deed of trust, which was recorded before the date on which the assessments that were due were enforced. So that deed of trust is typically recorded at the same time that the owner buys property, unless it's something like a second mortgage that they're taking out after the fact. So you will usually have that deed of trust recorded at the same time the warranty deed is recorded. And that deed of trust is prior to the HOA's lien, except under the exception statute where it says this super lien is prior to it. If there are liens for real estate taxes or other governmental expenses, charges against the unit, those liens, your property taxes, typically take priority over the HOA lien. So here's the exception part. and it talks about the super lien. And it's very convoluted language in the statute. And what it says is what I said before. There's a 6-month period of assessments, and that's the super lien. But you do have to have a deed of trust in order for the super lien to be effective. And so you have a lien. What do you do with it? What are your next steps to collect on that lien? And again, it doesn't have to be a hard copy recorded lien. It's a statutory lien for any assessments that are past due. First and foremost, send all the notices to the owner pursuant to the collection policy. Please read the collection policy and know what your requirements are, because not every association has the same requirements. And we realize that collections is a volume business. Just like it is for management companies, it's a volume business to get those notices out, but not every association has all of the same requirements. So please make sure you're checking that collection policy so that they comply with the policy as well as the statute, or we're going to ask you to resend them. Okay. If there's no response from the owner, they don't pay, they don't ask for a payment plan, the board then needs to vote to send the account to collections. Okay. Send over the delinquent account to your attorneys. If the balance exceeds 6 months of assessments, the board can vote to foreclose after following all those prerequisites that we talked about earlier. Sending out all the notices for mediation, sending out notices to lien holders, making sure that the owners have been notified that a foreclosure could be imminent, and obtaining a money judgment first. I also get asked this question a lot. How long does a foreclosure take? It takes a really long time. And I know that's what boards don't want to hear, but an uncontested foreclosure, meaning the owner didn't file an answer and say you can't foreclose on this property, it usually takes 4 to 6 months just to get a court order allowing the property to be sold. If HB 25-1043 passes as it's currently written, you can add 9 months to that time process, because the owner will be allowed to ask for a stay of the proceeding to allow them to sell the property. Okay. If the foreclosure is contested, meaning an answer was filed in some respect, whether it be by the owner or whether it's filed by a lien holder, then it can take a year or longer to get to trial. Typically, if an answer is filed by a lender, they will stipulate to lien priority. And stipulating to lien priority just means that the lender understands that the super lien has priority over the lender's lien. A lender will pay that super lien amount, and then their lien has 100% priority over the HOA's lien. But we'll usually be able to stipulate to that. They as in the lender will get dismissed from the lawsuit, and we just continue to move forward to get that order for sale against the property. Sometimes lenders don't like to stipulate, or they don't understand what the stipulation means. It's very infrequently that happens, but it occasionally does. I have a case right now that almost went to trial because the lender would not stipulate to lien priority, although we didn't actually disagree about anything. Once we do get an order for sale, the sale process for all the notices provided by the sheriff takes an additional 120 days to get to sale. And that does not include any additional timelines for alternate lienors to file their intent to redeem. So you see why it takes a long time. Foreclosure lawsuits get filed in the district court where the property is located. So if you have a property up in Boulder, that's where we're going to file the lawsuit. Our lawsuit names every party with a recorded interest that we find in the title that we receive. So we'll always order a title, and if whoever has a recorded interest, we name them as a defendant. Everybody has to be served with the lawsuit, so sometimes that takes additional time. Just like a collections lawsuit, you have to get it served. The nice thing about a lawsuit that involves property, like a foreclosure, is that if you can't get somebody personally served, you can ask the court, after you've made a number of attempts to get them personally served, you can ask the court to allow you to serve them by publication. It takes an additional 5 weeks to publish it, but that person then becomes served as of the last date of publication. So that is a little bit of a benefit to a foreclosure or an action that involves real estate. So we typically will negotiate with any defendants that's filed an answer, like I said, getting a stipulation to lien priority, get those done. And owners typically will pay, right? I mean, that was the whole idea behind a foreclosure, not to take the property, but just to get the owner to pay. And in the majority of cases, an owner will pay the HOA to stop a foreclosure. If they don't, then we go to a sheriff's sale. With the sheriff's sale, we put together all the documents that the sheriff needs. We send them out to the sheriff. They publish their notices. An owner under the statute can request a cure statement, and a cure statement is nothing more than a statement that says this is what you owe to stop foreclosure. They can ask for that up to 15 days prior to the sale under the statute. But if they reach out to our office and want the balance information, we'll provide that payoff at just about any time. We've done them the day of the sale, as long as certified funds are brought in before the sale happens. Property gets sold to the highest bidder, and all junior liens get extinguished by the sale. The redemption process that was provided for in 1337 and potentially might be revised even further now, just adds additional time, additional people that can redeem. And again, if anybody has any additional questions or wants more information on redemption, I'm happy to provide that. It's very nuanced. So there is an upside to foreclosure. I know I kind of talked about it in a very negative way today because the legislature has changed a lot of the aspects of foreclosure, but there are upsides. It typically pushes an owner to pay. Nobody wants their HOA to foreclose on them, and in most cases, people don't want to owe your HOA, right? You just want to get them paid, so they'll push an owner to pay. HOAs get paid in full from sales if there's a third-party bidder that buys it. Hopefully you get a new owner in the property that pays assessments and maintains their property, right? All upsides. Of course, there are downsides. When you have an upside, you always have a downside. If there are no bids at the sale and the HOA eventually becomes the owner of that property, the HOA is forced to sell that property at their own expense in order to recoup those unpaid assessments and expenses of foreclosure. And sometimes those properties have very little value to them, and it's hard to resell them. And you might end up taking pennies on the dollar just to not own the property any longer and recoup some monies from it. There are companies that specialize in buying distressed properties, and you may have to go that route to sell your property. Okay. You may also have to evict somebody. An eviction is a long, drawn-out process as well, especially if the owner contests being evicted. I should say the former owner, because they no longer own the property, but they might still be living in the property, and they can certainly contest an eviction process. Okay. The owner might file bankruptcy to avoid the sale. That does happen quite a bit. Okay. So if the owner files bankruptcy, there will be two forms of bankruptcy that they can file. You can file a Chapter 13. If they do that, then the debtor/owner has 60 months or 5 years to repay the balance that they owed at the time that they filed. So not only does the foreclosure lawsuit get stayed, the sale doesn't happen, the owner gets to pay that debt over 5 years. Okay. At some point during that 5-year period in time, the debtor may default on payments to the bankruptcy trustee, resulting in a dismissal of the bankruptcy, which is good for the HOA. Or they may keep paying the bankruptcy trustee, but then they stop paying their post-petition payments. So post-petition payments are just payments that became due after they filed bankruptcy. And then if they stop doing that, the HOA is required to take additional action to protect their interest in those assessments. Okay. In a lot of cases, owners that file bankruptcy are also behind on their mortgages. So if they don't make their payments through the bankruptcy case, then the lender may request through the bankruptcy court that that automatic stay that goes into place when bankruptcy is filed be lifted, which allows them to pursue a foreclosure, but also leaves the HOA then with unsecured debt instead of secured debt. If the owner files a Chapter 7, which is a liquidation, meaning there's no monies to go to creditors, the debt that's owed to the HOA is usually discharged in a 7, meaning that you cannot collect that money personally from the owner. There's still a lien on the property. If the debtor knows to ask to have the lien stripped, the bankruptcy court may agree to remove that lien, and then again, the HOA is left with unsecured debt. But if the lien remains intact, which it has in most cases over the last 5 or so years, that lien will stay intact. And once the bankruptcy is discharged and closed out, then the HOA can then pursue a lien, can pursue foreclosure on its lien. Okay. So here's the beginning question that we started with, foreclosure. Is it still worth it? There are going to be situations when, yes, it's worth it. And there'll be situations where, no, it's just not worth it to try to pursue this person for foreclosure just to collect this amount. But boards are ultimately going to have to make that decision if it's worth it for them or not. Okay. So that is all I have for you all today. I'm going to take a look at the questions and see how many of those I can answer, if I can remember how our IT person told me to do this. So there's a question, can the HOA keep the property and lease the unit? So I'm going to back up on that question just a little bit and assume you mean that the property's been sold through a foreclosure sale and the HOA ended up being the high bidder, or there were just simply no other bids, which made them the high bidder, and they received title to that property. Yes, they can keep the property and lease the unit. If they decide to keep the property and there was a first mortgage on the property, the HOA will have to pay that first mortgage, because chances are if that person doesn't own the property anymore, they are not going to continue to pay that mortgage and the lender will foreclose. And if the lender forecloses, they can take the HOA's property away from them. So you'll have to make some arrangement with the lender to get it paid. If there is no mortgage on the property, it's a very low likelihood that there won't be bids at sale. So it's a low likelihood that the HOA would own that property anyway. But yes, you can lease the property. You're responsible to pay assessments like any other owner. Let's see. So the question is, what is an example of a public notification? Is that still considered something like an advertisement in the newspaper? Yes, it actually is an advertisement in the newspaper. If you're publishing a notice, you'll look under the legal section in the newspaper. For those people that still remember a newspaper, you know, that the hard copy paper thing that you used to get delivered to you, or you can go pick up at a newsstand somewhere, that's a newspaper. And don't see those very often, but that is where you publish legal notices. And it's amazing to me that we still use that method for publishing notices, because I can almost guarantee you that 99% of owners don't look at legal notices or even look at newspapers. There are the online versions of those papers that will publish those notices as well. In a lot of cases, there's only the hard copy notice that gets published, but that's what I mean. And hopefully I answered that question. Sorry, I'm trying not to skip anybody here. So another question is, how might knowing a community's delinquency rate assist a prospective home buyer? That's a good question. Not really relevant to foreclosure, but if someone's coming in and wanting to buy in the neighborhood and there's a high delinquency rate, a prospective home buyer might not want to buy in that neighborhood thinking that, well, if there's a high delinquency rate, how are we paying for the services that are supposed to be provided? And so that's something they might want to consider. Question, doesn't the board have a duty to pursue all remedies available to collect an assessment debt? The board has a duty to collect assessments. They're going to weigh the pros and cons of each method of collection. For example, if you filed a civil lawsuit to obtain a money judgment and you got that judgment, you sent out interrogatories, which are just written questions, to that homeowner and asked them, where do you bank? Or you have a check, so you know where they bank, and you decide to file a garnishment, then that's a question for the board to answer. Is that what they want to do? Do they want to file a garnishment to try to collect that? And that's pretty much a question that goes by with very little thought. Yes, you have a judgment, try to collect on it. And garnishment is one way to do it. But if you're looking outside of the collection realm and you're thinking, should I foreclose? There might be some reasons you don't want to foreclose. You know, the notices are very nuanced, yes, but that certainly is not prohibitive to foreclose. But you may have to resend out your notices. the association may not have the funds to pay the attorney's fees. I said earlier that the legislature has limited the attorney's fees to the lesser of half of the balance that's owed, or $5,000. The association may not have the $5,000, $6,000, $8,000 that it actually costs to foreclose. And especially if there's a number of delinquent owners that they're considering, they just may not want to go that route because it's too expensive. So that they do have a duty, but it's duty within reason. And it is now just at 1 o'clock. I'm going to try and go through some of the other questions. If you all want to hang out, that's awesome. I would appreciate it, but I'll be happy to answer these. Thank you for your comments, Joy. Appreciate it. She said it was a great session. Okay, same question. So the question is, how about tax liens purchased first year, second year to ensure the first lien holder's interest in the property? Okay, tax liens and super lien, two different things. I'm not sure I understand the question. The person who sent that in, if they want to rephrase it, I'm still happy to answer it for you. I'm just not certain of what you're asking me. Question is, what's the prediction for HB 25-1043 passing and being signed by the governor? Is it struggling through legislative process or passing with flying colors and few amendments? So 1043 has been amended multiple times. More times, I think, than I've seen other bills be amended that are along the same line. I don't think it's going to pass 100% as written, and that is simply my guess. It could pass. Our legislators are very gung-ho about preserving equity for homeowners, which is a really lofty goal. It truly is. So it depends. I'm sorry, that's a terrible answer. I think it will pass. I just don't think it will pass the way that it's written. But there's also a monetary attachment to that in creating that department that provides information to homeowners. That's a monetary expense for our government. And so it may not pass for that very reason, that there's money attached to it, or they may decide to pull out that piece of the bill and have it pass as otherwise written. Question is it typical the lawyer that sends foreclosure notice to lenders? I've done it both ways. I prefer to send it to the lender myself because I'm going to pull a title report, or I'll get an O&E, and I already have a letter drafted to lenders telling them what's going on. So it is typical in our office that we send them. It may not be typical in all offices. Question is, there's two questions. How can we tell or know what Altitude has done with respect to handling an HOA request? You can ask us, send us an email, give us a call, check the status report that are available online. And if that doesn't answer your question, then please feel free to reach out again. Second question, we have a tenant that pays the owner, but the owner is not paying dues. The tenant's lease expires. There's an option to purchase the property. We've been told that the property is in probate. Can foreclosure happen? Okay, that's a really long, detailed question here. So I'm going to go with the owner isn't paying the dues, and there's an option to purchase the property. Okay, you can foreclose on that. You have to jump through all the hoops to do it, meaning that you have to send all the proper notices. You have to try and get a judgment against the owner first, and then send the other required notices before you can foreclose. And if the property is in probate, that's a different issue. Okay? We need to know that it's in probate, and we can look up the case and tell you what's going on with it. So please feel free to reach out to our office with additional questions on that or additional information, and we'll try and get you the right answer for that. I'll try and get to one more here. I don't want to keep you guys for too long. Okay, actually, that was my last question. So thanks everybody for joining me. I appreciate that y'all hung out with me, and please let me know if you have any questions. I'm happy to answer anything for you. Okay. Have a great day. I'm going to end